Thank you, Chair. I have prepared some brief heads of argument which I might perhaps be given leave to hand up.
Yes, thank you.
Just by way of introduction for those who don't have papers before them, such as the public, I'll just briefly sketch the situation that brings me here and then get to the heart of the argument. On the 31st of October last year, correspondence was addressed to Mr. Ajay Gupta, care of his attorneys. It was indicated that due to the fact that you are or may be implicated by the evidence of Mr. Manuel, you're entitled to attend the hearing at which that evidence would be presented. And the allegation is essentially that he unlawfully interfered with the appointment of Mr. Fikile Mbalula as a minister. The invitation is to Mr. Ajay Gupta to give evidence and to apply to cross-examine. Mr. Ajay Gupta did not so apply, but Mr. Ajay Gupta applied because he is aware, according to his evidence, that he congratulated Mr. Mbalula on his appointment as a Minister of State. He's aware that it wasn't his brother, but he doesn't admit that he congratulated him on being appointed as Minister of Sport. We know from press reports that Mr. Mbalula himself says it was not Mr. Atul, it was Mr. Ajay. Now, there is an argument that we may get to about the difference between Rule 3.4 and Rule 6. But representing Mr. Ajay Gupta, and as against a background of a ruling that you've already made, I have to address you as to why I can go any further given your ruling.
Yes.
Now, the attitude of Mr. Ajay Gupta, which you previously found to be not satisfactory, was that, and on our instructions, he views the NPA and the police, the Hawks, as being less than competent, and he drew to your attention the failed legal proceedings of an asset forfeiture nature where they completely misunderstood banking and the facts at their disposal, and which launched a much publicized raid, arrest, stringent bail conditions for parties, much fanfare in the press, all very detrimental to the Gupta family and the so-called Gupta companies. And in effect, we predicted through our clients that all of this would come to nothing, and that would be demonstrated as to the accuracy, according to our instructions, of the abilities of the NPA and the Hawks. What has developed since then is that, not with a bang but a whimper, that all came to an end with all those charges withdrawn, people's liberty interfered with for nothing, opposition to them traveling overseas, all for nothing. The charges are gone. They are said to be gone provisionally, but we know all charges are withdrawn provisionally, so that's a meaningless statement. Against that background, and against this submission, I'm instructed to ask you, everyone has absorbed and observed the progress of the Commission. No one has yet been cross-examined. There's just been a, if you like, one-sided presentation of evidence. In order qualitatively to assess the validity of all of this evidence, in particular, just for example, the dramatic evidence taking place at the moment, someone will have to test the veracity of that evidence. In relation to the Guptas, though, pertinently, you will be unassisted if there is no cross-examination on their part. Presumably, the legal representatives that they appoint would have the skill to cross-examine, even in the narrow confines that may be imposed, but can only do so on instructions. You will not test the validity of that evidence, and your finding at the end will be a limping one. So what is the difference between when you last ruled and now? Our prediction by our client that all of this would come to nothing, that those powers that can interfere with freedom of movement, possible imposition of temporary imprisonment for a short or long period by means of opposed bail applications, have been shown not to have the ability.
If I remember well, Mr. Helens, I said in my previous ruling in relation to the application for leave to cross-examine that Mr. Ajay Gupta, Mr. Atul Gupta had brought, I said that I would have absolutely no hesitation in granting them leave to appeal, to cross-examine if they overcame the hurdle that we had in that matter, in that application. I think that's what I said in the light of the allegations against them. So what?
Well, their position
so it's
had...
not. So it's not a situation where, in regard to them, it's not a situation where there is doubt that I would grant them leave if that hurdle were to...
The hurdle is their undertaking to come back here and give evidence in person. That hurdle remains.
Yes.
We say that the hurdle is a much smaller hurdle, which in your discretion you can hop over, in the light of the fact that what they said would happen has happened. There has been a completely incompetent prosecution of all of these people, costing them enormous time, trouble, financial cost, embarrassment, all for nothing. So that is essentially the position, coupled with, I'm sure from the dawn of this commission, you've always realized that evidence would have to be tested in cross-examination. But as the commission has ground on, and as certain people have faltered, perhaps even in chief, or looked dubious in the witness box, we would urge upon you to recognize the valuable tool that cross-examination would be in the hands of someone with information with which to cross-examine, a version. And the tender, of course, again is made of the video conferencing evidence. But their attitude remains, and they say fortified by the demonstrated failing of the Estina dairy matter. So that's a starting point. From there,
Yes.
we would go into the balance of the argument, which involves Rule 3, 4, 6,
Yes.
Mr. Atul Gupta not being here, Mr. Ajay Gupta being here. But it
Yes.
seems to me that this commission has substantial work to do.
Yes.
And if we don't pass this hurdle,
Yes.
the rest is academic.
Yes. No, I think that would be certainly a prudent use of our time. As we speak, I don't see that there is anything that would make me go against the ruling that I have made. So I don't know whether in regard to that you have anything further to say.
No, Mr. Chairperson, on that narrow and yet wide issue,
Yes.
I have coupled today's argument with my previous argument with
Yes.
a brief analysis of your previous ruling.
Yes.
And if your ruling remains the same,
Yes.
then I'm debarred from addressing you further.
Yes. Okay, all right. No, thank you very much.
Thank you, Mr. Chair.
Thank you.
Chair, I'm not sure whether you'd wish to hear me. I would
Well,
limit myself to the matter that you discussed with my learned
Yeah,
friend.
well, I wanted to say you have heard what I've just
Yes.
said. I have serious doubts that you want me to change that view.
Perhaps may I just say one thing to reinforce that view, Chair?
Yes.
The only reason which a learned friend gives as to why you should change your view is that the prosecution has been stopped, whether temporarily or otherwise. With respect, all that does is vindicate the correctness of what you said right at the outset, that people who are arrested have the right to appear before the courts, and the courts will do the job, and people who are wrongly arrested will be released. And so it's not a matter that what Mr. Gupta said has been vindicated by the events, what you said has been vindicated by the events, and we submit there's no reason at all for you to change your ruling in a case where, unlike in the previous case, Mr. Gupta is not even implicated in the state evidence which was given, and he actually has no personal knowledge of what happened at the meeting in question. This is a weaker application than the previous one, and nothing we submit has changed, which ought to lead you to change your view. Thank you, Chair.
Thank you. Well,
Thank- Thank you, Chair.
Yes, Ms. Tabasha, I guess you have really nothing to say.
Absolutely, sir. I simply thought I should come up and say we abide by that rule.
Okay, no, that's all right. I've had the application brought by Mr. Ajay Gupta for leave to cross-examine Mr. Manuel. Mr. Helens, who appeared on his behalf, presented argument in relation to the basis on which I previously dismissed his application for leave to cross-examine in the ruling that I made in September last year. Having listened to him, I am of the view that there is no basis for me to grant Mr. Ajay Gupta leave to appeal, to cross-examine, because the hurdle which stood in his way in terms of that judgment remains. Because of that, it is unnecessary to deal with other arguments, and Mr. Helens acknowledged this. In the circumstances, the application is dismissed.
Thank you.
Thank you.